Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this content, please remember to subscribe. For today's content, we have Donald Jan Trump versus the state of New York when it comes to the census. Donald Trump ordered that the Secretary of Commerce, who runs the census, provide to him information as to the number of illegal immigrants in the United States as part of the census determination. The state of New York didn't like that, and they went to lawsuit over it. So in today's case, we're going to find out whether or not Donald Trump was able to order the Secretary of Commerce to give this information and whether or not it is a violation of the Constitution. Let's get started with this. Every 10 years, the nation undertakes an enumeration of its population in such manner as Congress shall by law direct. The census plays a critical role in apportioning members of the House of Representatives among the states, allocating federal funds to the states, providing information for intrastate redistricting, and supplying data for numerous initiatives conducted by governmental entities, businesses, and academic researchers. So the census is actually pretty important because, first of all, it determines how many representatives every state gets, so that's pretty important. And also, determining where people live and their demographics is helpful in when you're figuring out what programs to run and where. So it's a pretty notable deal. Congress has given both the Secretary of Commerce and the President functions to perform in the enumeration and apportionment process. The Secretary must take a decennial, and that means every 10 years, census of the population in such form as content as he may determine, and then must report to the President the tabulation of total population by the states under the census as required for apportionment under the law. The President must in turn send to Congress a statement showing the whole number of persons in each state, excluding Indians not taxed, which I'm not sure there are any anymore, but whatever, as ascertained under the census. In that statement, the President must apply a mathematical formula called the method of equal proportions to the population counts in order to calculate the number of House seats for each state. So, yeah, the President determines the census, or more properly, the executive branch does. So the census is done by the Department of Commerce, who then reports to the President, and then the President reports to the Congress on all these numbers. And he has to report the whole number of persons in every state and how many seats every House gets. And there is a complicated method to determine this, was shown in a CGP Grey video. It was like an outtake video of his, which showed it. But basically, every state gets one for free. And then you have to determine which state is like the least, well, it's complicated, but there's a formula for this that they have to follow to determine how many House members every Senate gets. So he has to determine the whole number of states and the apportionment related to this. So that's part of the law. This past July, the President issued a memorandum to the Secretary respecting the apportionment following the 2020 census. The memorandum announced a policy of excluding from apportionment base aliens who are not in a lawful immigration status. So they want to exclude illegal immigrants, which may or not be in compliance with the Constitution, but that's what they wanted. The President ordered the Secretary in preparing the report to provide information permitting the President, to the extent practicable, to exercise the President's discretion to carry out policy. The President directed the Secretary to include such information in addition to tabulation of population according to the criteria promulgated by the Census Bureau for each counting of each state resident. So the President said, please tell me how many illegal residents there are so I can, to the maximum extent allowable by law, exclude them from the census. So, okay. A foundational principle of Article 3 is that an actual controversy must exist not only at the time the complaint is filed, but through all stages of litigation. As the plaintiffs concede, any chilling effect from the memorandum from the President dissipated upon the conclusion of the census response period. So the President's memorandum, which was incidentally to the Secretary of Commerce, any chilling effect it could have theoretically had on the public at large, which is the plaintiffs who sued, evaporated once the census was done, because there's nothing left to influence. The plaintiffs now seek to issue an alternative theory of a legally cognizable injury premised on the threatened impact of an unlawful apportionment of congressional representation and federal funding. As the case comes to us, however, we conclude it does not, at this time, presently issue a dispute that's appropriately resolved through the judicial process. So this lawsuit is not appropriate for a judicial determination at this time. Why? Well, first of all, a plaintiff must demonstrate standing, including an injury that is concrete, particularized, and imminent, rather than conjectural or hypothetical. So, yeah, the state of New York sued the Trump administration and said, well, you can't ask these questions because, one, this might in some way prevent people from wanting to respond to the census. And number two, we might not get the number of seats that we're entitled to. And the court has two basic responses to this. As to number one, people might not respond to it. Well, the period for response is over. So that already happened. And as to number two, that you might not get the seats you think you do, well, that's just speculative. You don't know that yet because the harm hasn't fallen. So you don't have standing, state of New York, to sue the Trump administration. So we're going to throw it out for lack of standing. So everyone in the chat gets to decide how much they do or do not like the standing doctrine now that Trump was able to get a lawsuit thrown out from the state of New York because the state of New York didn't have standing to sue Trump. How much do we like the standing theory today? Do we like standing or do we not like standing? I'll let you figure it out. Maybe standing is BS after all. Maybe standing is BS. And maybe New York should be able to sue Trump for harms that are in the past, are moot, or are speculative. They're not ripe yet. So maybe standing is bullshit. Maybe this lawsuit should go forward because standing is crap. And New York should be able to bring their complaints and have Trump cower before them. What do you think, guys? Do we like standing or not today? I'll let you figure it out. At present, this case is riddled with contingencies and speculation that impede the judicial review. The president, to be sure, has made clear his desire to exclude aliens without lawful status from the apportionment base, but the president's qualified his directive by providing that the secretary should gather information to the extent practical, and that aliens should be excluded to the extent feasible. Any prediction on how the executive branch might eventually implement this general statement of policy is no more than mere conjecture at this time. It is not harm that has actually occurred. Your case is not ripe yet, New York, because any harm is purely speculative. Therefore, there is no harm to you. Therefore, there is no standing. State of New York. Right. To begin with, the policy may not prove feasible to implement in any manner whatsoever, let alone in a manner substantially likely to cause harm. So the policy may not be implementable at all, let alone in a way that would actually cause any harm. Pre-apportionment litigation always presents a moving target because the secretary may make, and the president may direct, changes to the census right up until the time the president transmits it to the House. So until he actually does it, it doesn't exist yet. He can actually make changes along the way, as accordance with the law. And the government recognizes any such changes must comply with the constitutional requirement of an actual enumeration of the persons as opposed to a conjectural estimate. So you actually have to provide the number of persons, not what you think is there based on conjecture. Trump can't do conjecture, and the state of New York also can't deal conjecture. We deal in reality. While the plaintiffs agree that the dispute will take a more concrete shape once the secretary delivers the report under the law, they insist the record already establishes a substantial risk of reduced representation and federal resources. That conclusion, however, involves a significant degree of guesswork. You don't know. You're guessing. You're speculating. The injury hasn't occurred yet, so you don't have standing. Unlike other pre-apportionment challenges, the secretary has not altered a census operation in a concrete manner that will predictably change the count. So nothing actually bad has happened yet. You're only guessing at things that might happen. Everyone agrees by now that the government cannot feasibly implement the memorandum by excluding the estimated 10.5 million aliens without lawful status. And that is read that very carefully what it's saying. It doesn't say that you can't do it. It says you can't feasibly implement it, which is different. This is where language really, really matters. Everyone agrees the government cannot feasibly implement it. The reason we can't feasibly implement it is because we're not really sure how many illegal immigrants there are. And one of the reasons we're not really sure is because that question was struck from the census. And the reason it was struck from the census is the question was improperly promulgated. We covered that on a prior case. So at this point, it can't be feasibly implemented. Would it be legal if it could be? The court isn't saying one way or another. The only evidence speaking to predicted change in apportionment unrealistically assumes the president will exclude the entire undocumented population. Well, that would be the only alternative because we don't know exactly who they are and exactly where they are. The only thing that the president could theoretically do would be to exclude all of them uniformly, even though we're not quite sure where they are. Nothing in the record addresses the consequence of a partial implementation of the memorandum, much less supports the dissent's speculation that excluding aliens in ICE detention will impact interstate apportionment. So the court is pointing out that this memorandum is not really implementable because we don't know where the illegal immigrants are. We don't know where the illegal immigrants are because the question was struck from the census. It was struck from the census because the Secretary of Commerce improperly promulgated the question in violation of the Administrative Procedures Act. We covered all that before. So at this point, the memorandum is not doing anything. And New York says, well, we're going to be harmed. And the court points out there's no reason to think you can be harmed because they have no reason to know where the illegal immigrants are. And the only thing the Trump administration could do would be to exclude all of them universally. And we have no reason to think that they're going to do that, because that would be a pretty strong violation of the law as it happens. So we're not going to assume that they do that. So as a result, you're not standing. It's too speculative. The remedy that was crafted by the district court underscores the contingent nature of the injuries. In its injunction, it prohibited the secretary from informing the president in his report of the number of aliens without lawful status. So the district court said the Secretary of Commerce couldn't tell the president the information that he asked for, which is a problem. In addition to implicating the president's authority under the opinions clause, so the president has the authority in the Constitution to get opinions from his principal officers. So the district court saying you can't give information to the president is probably unconstitutional because the president has specific authority to get opinions from his principal officers. The injunction reveals any source of the injury to the plaintiffs in this action the secretary or president might take in the future to exclude unspecified individuals from apportionment base, not the policy itself in the abstract. Letting the executive branch decision-making process run its course not only brings a more manageable proportion to the scope of the dispute, but also ensures that we act as judges and do not engage in policymaking properly left to the elected representatives. So again, this is a judicial restraint philosophy. This is a philosophy that the judicial branch should not solve all problems because the judicial branch is not elected by the people. They are appointed, and so their role is properly constrained as a result. We don't want the judicial branch doing policy. That's a very conservative legal philosophy, incidentally. Very conservative legal philosophy. Twofold. One, we don't want the courts doing policy. That's very conservative legal philosophy. And because the more progressive legal philosophies have the judicial branch doing more stuff. So doing less stuff is a very conservative legal philosophy. And also, we're not supposed to reach beyond our turf because things that are political should be political. So yeah, this is very political. So it's a judicial philosophy of restraint that we are not here to solve every problem. Most problems should be solved by the political branches, not by us. So, very consistent with conservative legal philosophy. At the end of the day, the standing and ripeness inquiries both lead to the conclusion that judicial resolution of this dispute is premature. Consistent with our determination that standing has not been shown, and this case is not ripe, we express no view on the merits of the constitutional and related statutory claims. We hold only that they're not suitable for adjudication at this time. Thus, that brings us to the end of the case of Donald Trump versus the state of New York. In this case, Donald Trump wanted some information from the Secretary of Commerce about how many illegal immigrants there are in the United States. For what purpose, it was a little bit vague. And New York said, well, this is going to harm us. It could harm it because people won't respond to the census. It can harm us because we won't get the number of seats we're entitled. And the Supreme Court says, well, you don't have standing because the census is already over, so that doesn't work. And as to the number of seats, it's purely speculative. You have no reason to think this is. So, the district court giving this remedy was improper. So the Secretary of Commerce can report to the president the information. He can do with it what is legal under the law. And if he does a bad, then we can hear that case. But you don't have standing now. So this case can't be filed now. So that, for the moment, brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.